Good afternoon, everybody, and thank you for joining us for the third in our series of MCA webinars this afternoon. I'm very pleased to introduce Jacqueline Thomas, Queen's Counsel. She's a wealth of background in family and care law and a substantial practice now in court of protection law. So she's ideally placed to speak about transition for young people to adult social care. I'll now hand you over to Jackie. Thank you.
Thank you very much, Alison. I shall just share my screen to get us started. Thank you, Alison, for inviting me to speak this afternoon. And we're going to spend the next hour or so looking at the transition for young people from children's to adult social care. As Alison's just said, my practice is in both childcare law and child protection and adult safeguarding, and quite often the cases that cross between the two. And this is an area in which I think it's important for practitioners within mental capacity law and the Court of Protection to have an understanding of the various obligations and duties that are held by public bodies around those young people that they're working with. So if we just have a look at the challenges, because this is an area of law which I think in general a lot of practitioners find very difficult, as do the families who are having to live through these various scenarios. There are a number of principles of law governing transitions around the move from children's social care to adults. There's a lot of overlapping legislation, which we'll come to in a moment. We'll have a look at that legislation and the various different schemes, where they conflict and where they overlap, and the regimes that practitioners need to be aware of. We'll have a brief look at the deprivation of liberty scheme for young adults. I know that you have already lined up as part of this Switalskis seminar programme another seminar later on the liberty protection safeguard. So I'm not going to go into it in very much detail, but it is important that we just touch on it as it relates to transitions. We'll need then also to have a look at the various jurisdictions and which courts you may be coming into contact with as practitioners. So understanding the roles between the Court of Protection and the Family Court and where they overlap, and how cases can sometimes very usefully move between the two. And then towards the end of the hour, we'll have a look at vulnerability outside of the Mental Capacity Act. So that relates to cases that might find their way into the inherent jurisdiction, and how that sometimes the safety net of the High Court can be a very valuable tool to know about and to bear in mind when you're working with teenagers and young adults. So those are the main areas that we'll cover over the course of the next hour. In terms of the various provisions then for children and young people, and this really ties into the reasons why I say it's important for practitioners in the Court of Protection to have an awareness of the schemes that the children, or as I say, young adults really, may have come from. But it's important, obviously, to be able to identify which public body is going to be responsible for meeting duties towards the teenagers as they moved into adulthood. There's often overlapping roles between local authorities, the involvement maybe of the CCG, which might come as a new factor because it's only at 18 that community continuing healthcare funding becomes available. There may also have been a role for education within the local authority, and there may be roles for education moving forward, and we'll have a look at some of the provisions around the education sphere. So this is an area which overlaps very much with education law as well, potentially, as care law. It's also important, once you've looked at which public body might be involved, to consider the specific vulnerabilities of the young person. So clearly, if you're working with a case within the Court of Protection, there will be vulnerabilities around their mental capacity and any mental impairment that have brought them before the court. But there may also be a history as a child in care, and that alone gives rise to various obligations on public bodies, which may mean that the child and their family are able to access further support. There may be vulnerabilities, as I've already said, around educational needs, and a host of others that family has lived through. It's also important, I think, and I'm often told by social workers that they find this age group, by which I mean probably around 15 to 16 and above, that they often find this age group to be one of the most challenging in terms of assessing mental capacity and establishing whether or not there are concerns actually around capacity, or whether this is a case in which a young person is taking an unwise decision. So, for example, the teenage girl who is choosing to sleep in the car on the corner of the woods rather than go home with her boyfriend, who people think is exposing her to sexual exploitation, that might very rightly give rise to concerns around her protection and whether or not she has the mental capacity to make those decisions. But equally, we have to be cautious of imposing perhaps a best interest position on what is actually an unwise decision, but one that teenager is able to make for herself. And that brings me on to the last point on that slide, which is that quite often with this age group, there is a real tension between what's sometimes referred to as the protective imperative, the paternalistic approach taken by children's social care, as opposed the need and the obligations to support someone's autonomous decision making as they move forward into adulthood. And that's often quite a different approach, and it's not one that social workers may always be comfortable taking, and it's always one, I find, at least in my experience, that families struggle with as their children are moving towards independence. So those are some of the challenges and the maze, as I've put it, that you'll have to work your way through with dealing with this particular age group. Just to give you a little bit by way of background, back before 2002, Children's Services was part of the same service provision. And I'm sure some of you are aware of this from the time. They were working alongside adult services, and in fact, they weren't divided up into different teams. They were simply social care. And there were then concerns highlighted through the Colombier report about fragmented decision-making that was being seen, and really a need identified for some specialist children's services to come into effect so that they could specifically plan and finance and provide services for children. That then created a split between the various departments in local authorities up and down the country. And although seen at that time as extremely useful in terms of the specialism that it then brought, particularly to children's services, the consequence is that now there is always a risk, and it's certainly not one that's seen everywhere, but there is sometimes a risk that children's social care are managed very separately from that involving adults. And sometimes that results in what families feel is something of a cliff edge. Bearing in mind that a lot of the families that are involved in these cases are also dealing with medical professionals as well as social care, and anxieties around what's going to take place with a transition to adult medical services as well. The fact that there are sometimes very separate teams within local authorities isn't always helpful. Now, certainly I've experienced of those authorities that have transitional teams as well to bridge that gap, which is extremely useful. But it can mean that a family has input from a children's social care team, transitions, disabilities, potentially some educational input as well as then dealing with any clinical input. So it's a whole host of change and sometimes different professionals that the families are being asked to deal with and take on board. And that all feeds into the stresses when they then find themselves presented with a dispute, which perhaps has to come before one court or another. So it's easy to see why families and parents in that situation become extremely frustrated. There's also, of course, differences in the service provision itself. So expectations have to be managed along the way. For example, adult social care, as we know, is means tested. There's consideration around how that's financed, whether or not there's personal budgets, direct payments, a different landscape, really, I would say, for families to be looking at. Also, just to add to that, there is, I think, a great difference, and again, this comes back to managing expectations that parents might have around the service provision. So, for example, I've certainly had experience in cases where parents who have been visiting disabled children who have been spending time in care as children, those parents have received help with travel expenses. They've had travel sometimes arranged for them in the form of taxis. They've received that type of assistance through children's social care. And that's because whilst the child's in care, the local authority have an obligation to promote that contact. Obviously, once that moves to adult social care, and this is just one example of an area that I'm aware of having caused disputes, the provision is very different. And as a general rule, adult social care do not fund families so that they can go and visit adult residential care. So there's a different level of expectation, and matters that social workers will have to look at, but it, to a family, can be a very jarring experience. So if we have a look at the legislative framework for this age group, these are just some of, it's not exhaustive by any means, but these are just some of the various statutes that come into play when you are dealing with a child of around 16 years or over. The Mental Capacity Act has jurisdiction from age 16 upwards. The Children Act and matters such as care orders have jurisdiction up to the age of 18. The Care Act looks at transition starting from around year 9, so that's approximately age 14. And although I haven't included it on here, the NICE guidance for transitions within medical settings is also from around the age of 14. So you can see already that within those three primary pieces of legislation, there is significant overlap. You then have matters which we'll come on to in a bit more detail in a moment, such as the Children and Social Work Act, Children and Young Persons Act, which establishes duties for care leavers, the Leaving Care Act, and the Children and Families Act. And within each of these statutes, and underpinning them, there are regulations. I've given you one example there of the Leaving Care regs. But as you'll all know, there's then the Mental Capacity Code of Practice, there's the Care Act guidance, none of which are small or light reading in themselves. And there's a host of regulations beneath the Children Act. So in terms of navigating the appropriate duties of a public body, there is a great deal to be considered, I would say, when you're faced with a case of maybe a 16-year-old care leaver who lacks capacity, who now needs some best interest decisions being made before the Court of Protection, and you're considering what duties the local authority hold and what it is that that young person may be benefiting from or should benefit from. And just the fact that they are so overlapping, it gives you some idea there. We're going to look at some of these in a little bit more detail, and I'll start with the Care Act from 2014, which I know will be common use for a lot of you, and the community care lawyers out there who will be very well aware of this. But it doesn't hurt to recap because it's a very good starting point for transitions. And as you'll all know, the Care Act was intended to replace a whole host of community care legislation. I think it was around 60 pieces of overlapping legislation at the time that it was intended to codify and simplify. It's accompanied by guidance, which is updated regularly, and Chapter 16 deals with transitions specifically within that guidance. And as I've said on that slide, Section 58 to 66 of the Act itself deals with transitions, so they have their own standalone area. And the Care Act really was the first piece of legislation to look at three distinct groups and what support they might need, that being the young person themselves, the young person if they're working as a carer, within their own family, and actually any adult carers that are involved with them. And it was seen as quite groundbreaking, really, in that regard. So the Act tells us that if a young person is likely to have needs for care and support, or support themselves as a carer, when they transition to adult social care at the age of 18, then they're entitled to have a transitions assessment. And the Act sets out in some detail, along with the guidance, what's to be included in that assessment, the timing of it, and the factors that are being taken into account. Now, in terms of timing, within the Act, there is no set age or point at which young people should have these assessments. It's said that it should take place on when it's going to be a significant benefit to the young person or carer. And it's a question of judgment for the social workers on the ground. It's pointed out that those in receipt of children's services are highly likely to have needs, and therefore assessment should be carried out. So that's a good place to start if there's already been a background of children's social care. So that means that a local authority have to consider whether or not it's of significant benefit to assess at a particular point in time. And they have to think about things like the educational stage, any upcoming exams. These assessments should be conducted at a least disruptive point in time. Whether the young person or their carer have aspirations around higher education that an assessment could help with, whether there's any changes in accommodation planned, and changes that may be afoot in terms of planning and putting in place adult care and support, as well as any relevant family circumstances or any other significant matters such as medical treatment that are scheduled. So all of that has to be taken into account. There's then those young people with education and healthcare plan. And this is also laid out in another piece of legislation, which we'll come to in a moment. This plan, if there is a plan in place, then assessment has to start from year 9 onwards. And as I've already mentioned, that does correlate with the NICE guidance. And there's a number of other factors that might point towards an assessment being needed. One area which I know always troubles practitioners is that around the young person's engagement and consent, because sometimes this age group aren't the easiest to engage with, and it may well be that they have told their story too many times and they don't want to be involved with any further services, which can make any form of assessment, be it capacity or otherwise, extremely difficult. And in those circumstances, the advice from the Care Act point of view is that an assessment should be carried out at a time when the young person is in a position to consent, and that if they don't consent, work should be done with them to enable them to come on board with that. Obviously, that's sometimes much easier said than done, and where there's safeguarding concerns, assessments should take place in any event. So that's in terms of the timing of assessments. Just in terms of the content of them, the part that it's probably important to flag is that these assessments can and should be joined up with other assessments. So, for example, assessments under the Children Act, Section 17, or any assessments that are ongoing in terms of education, as well as those under the SEND Code of Practice. And the Code of Practice for SEND sets out very clearly the ethos that a child should only have to tell their story once. There shouldn't be a need for repeated assessment. Because again, it results in assessment fatigue effectively, both for the young person and for their family. So once the Care Act assessment's been done, that should lead to the consideration of a transition plan. And it's recognised, I think, throughout the guidance that there is often a difficulty for families in understanding the difference in provision, as we've already said. What's potentially unhelpful, I would suggest, is that within the year of 2014, we had the Care Act and the Children and Families Act 2014. And they clearly overlap, and they were enacted within the same year. So the Children and Families Act 2014 sets out a system of support from birth to age 25, whereas the Care Act focuses on over 18 years old, and they do therefore clearly overlap. The Children and Families Act 2014 specifically has a transition section, which, given that the Care Act is also engaged with that, is perhaps less than helpful, that you have to look in that situation at both sets of legislation. So the Children and Families Act considers transitional provisions. It's very much geared towards young people that have maybe been in care. So it puts, for example, the idea of a corporate parent on a formal footing and the staying put arrangements. So it may well be that you have a case within the Court of Protection where a young adult is staying put under those arrangements with their foster carers, and as they're now entitled to do. And then within the second part of the Act, well, part 3, as I've said there, the second aspect of this is that it imposes duties to assess education and healthcare needs, and it updated the SEN regime considerably. So if you're faced with a young person, whether or not they're coming from the care system, but they have SEN needs as well as mental capacity concerns, and then potentially having spent some time in care, these are all the provisions and the overlapping duties that you'll need to be aware of. One thing, just to go back to the Children and Families Act 2014, I've said there the system of support goes from birth up to age 25, and it does. We'll come in a moment to a more recent piece of legislation which extended education provision, but now the position is that for care leavers, regardless of whether or not they have been in full-time education before, there is an entitlement for education provision up to the age of 25. And of course, those of you that do work in this area will be aware that that's education in the holistic, widest sense, not necessarily education as we'd think of it in more mainstream sense. There is a really useful piece of guidance that exists from the Council for Disabled Children, where they have compared and contrasted the two 2014 acts. And they set out very clearly within, I've given you the link to it there, the differing areas and where effectively the acts are trying to achieve the same aim, but perhaps in slightly different language. And they also flag that interaction with health, which I've already mentioned to you. So we then come forward in time from 2014 through to the Children and Social Work Act of 2017. Now, this piece of legislation, at the time that it was enacted, was aimed primarily and attracted an awful lot of media attention for the reforms to social work regulation and social work training and registration. But within the Act, it deals expressly with transition cases. So again, you can see that perhaps this is why I'm somewhat dismayed every time I speak on this topic, to have to really embark upon a journey through so many different pieces of legislation. Because if it's difficult for lawyers to navigate, it will be 100 times more difficult for the families involved. And unfortunately, transitions is an area in which we remain really with lots of duplicate pieces. So you have the 2017 Act that talks about the need for a local offer, which isn't a new idea. That had featured previously in care leaver legislation, but it's reiterated within this Act. It sets out the fact that local authorities have to give information about a number of different services, which I've listed there. And importantly, and this is perhaps the part that you might come into contact with, the Act extends the duties of local authorities to care leavers up to the age of 25. So that means that care leavers are entitled to receive services until the age of 25 years. That will clearly overlap with any adult social care services. And it means that if you have a 17 or 18 or 19-year-old before the Court of Protection, you are aware that they've spent time in care, and we'll come to the definition of a care leaver in a moment. But if you're aware that they have spent time in care, then regardless of mental capacity concerns, you can be looking for not only any Care Act assessments that have been done, but also the role of their personal advisor, a pathway plan, any advice and support that they can tap into via care leaver services. And it's sometimes an important other strand alongside any disabilities work that is sometimes helpful to remind local authorities that they do carry these duties as well. I've certainly had it said to me in court of protection cases that these type of services add nothing to mental capacity cases and very much are passed over to the disability team. I'm sure that's not the case in all authorities. And when you look at actually the services that should be on offer and should be perhaps giving an enhanced position to care leavers who carry their own level of life experience and vulnerability, services including participation in society, there's no reason why that shouldn't be a service that everyone should be able to access regardless of mental capacity. So it's something certainly I feel quite strongly that we should be promoting for our younger clients within the Court of Protection. I'm only going to mention a couple of Leaving Care Acts briefly because of the language that's involved. And it's just useful to have them if you are an adult safeguarding practitioner. It's useful to have an awareness of them. So the first of those is the Children Leaving Care Act, which is now obviously some time ago. But this is where really the origin of pathway plans and personal advisors for care leavers come in. And the regulations to this act describe that if a young person has spent a period of time or periods all adding up to 13 weeks, and if those periods began after they reached the age of 14 and carried on until after they reached the age of 16. So you can see from that, this can cover respite, it can cover short break provision, which is often in place for family carers. It doesn't have to have been full-time care in the sense that we might think of it. So if they've spent those periods of time and it's only the period of 13 weeks as a minimum, then they are described as having been looked after. And it's that then that triggers their right to be able to access these further services. And I've said there that it was accompanied by various regulations, as all of these are. They've all obviously been updated over the years. And then very briefly, 8 years later, we had the Children and Young Persons Act. At this stage, care leaver provision was looking very much at up to the age of 18, and it introduced the role of the independent reviewing officer. What is terrifying, perhaps, when you look back at some of these acts, and 2008 isn't that long ago, but for example, it said within this act that, and it's spelt out that, for example, the local authority have a duty to visit children who are looked after, which we would now expect perhaps rather as a given. So to see it having to be spelt out in black and white at that stage is somewhat alarming, but there was clearly felt to be a need for it. All right, so we've looked, and that was a very whistle-stop tour because I'm already halfway through my time, but we've had a look there at the overlapping statutory regimes. All of that means, though, that as lawyers working in this area, you have to also then navigate overlapping court jurisdictions and have an awareness of the fact that you will also sometimes have alternative routes that you can take and advise about. So there are three primary jurisdictions, I would say, for this age group. And you can see there, we have the Court of Protection, which I know most people at this conference will have a primary interest in. There's also then the Family Court, which retains jurisdiction up to the age of 18 or 17 for care orders in effect. And then as what is sometimes called the safety net, we have the inherent jurisdiction, which is there only to be used if no other jurisdiction can provide the answer effectively. It is certainly not a first port of call. It's there in the background. So I've suggested at the side of that slide that for those young people who are 16 years and above, because the Mental Capacity Act, which underpins the Court of Protection, affects from the age of 16. And of course, the gateway to that jurisdiction is a lack of mental capacity to make a specific decision, then their decision-making could fall within the Court of Protection. However, simply because a young person does lack that mental capacity doesn't mean that the family court necessarily loses jurisdiction. And there are cases, certainly, where both the family court or the Court of Protection would be a perfectly valid route to resolve a dispute. Obviously, the family court is there as well for those 16 and above year olds who have mental capacity and can't therefore be looked at by the inherent jurisdiction. In terms of the inherent jurisdiction and its role, as I've already said, it is a safety net. It exists throughout, although I've said there 16 years and above because I'm concentrating on transitions, but the childcare lawyers amongst you will know that the inherent jurisdiction exists as an entity from effectively birth to make decisions that aren't otherwise dealt with within statute. I've certainly, and I know the case law and authorities that look at perhaps what, and I'm interested in the areas where these things overlap. See, for example, combined cases within the Court of Protection and the inherent jurisdiction, where there's maybe queries around difficult areas of capacity, and there's concerns around capacity assessments and whether or not they are sufficient, or where a young person perhaps has a capacity to make a decision in one decision, but not in others, in one domain and not in other areas. And those other areas can then be looked at. So it is there, and it's certainly useful to have an awareness of. Just in terms of whether or not a case should stay or go to the Court of Protection or to the family court, there's provision made, which most of you will be familiar with, I'm sure, but to transfer proceedings between the two jurisdictions, either from the family court to the Court of Protection or back the other way. And the overriding test set out really within the regulation is where it's just and convenient. And the court has to take into account various factors that I've listed there that come from the regulation itself. For example, and just to give you a working example of where this can be seen, if there is a young person who has been in residential care as a result of brain injury, there is a care order in place, and his father now wishes to start taking him out unsupervised without his qualified carers, and eventually then wants to be able to take him to live with him at home when he becomes 17 or 18. In that case, and as happened in one of mine, the parent can issue proceedings specifically for contact arrangements to be dealt with within the family court, and the family court has jurisdiction to deal with that contact up to the age of 18. But where a parent is saying, well, actually, it's not just the contact, I also want him to come home, and that's going to be a longer term decision, then it's perhaps more appropriate for the Court of Protection to be brought into play and to address matters. And there's been some case law around the transfer of proceedings. So Mark Headley gave consideration to it some time ago. And I've set out there the main questions that he asked himself. Perhaps the most central, or perhaps one of the most useful, is to think about whether or not the decisions that are arising can all be taken and all be dealt with and resolved during the child's minority. Because if they're longer term decisions, then rather than have to recommence proceedings in only a year's time, it would perhaps be preferable to move sideways into the Court of Protection. And as I've said, the regulations provide for you to be able to move the other way as well, although in my experience that's less common, but there's no reason why not. The REAF case is a good example of when it was considered not to be necessary to move into the Court of Protection, despite a lack of mental capacity on behalf of the young person. And this was a Mumby case that's perhaps better known for its role in the deprivation of liberty bank of cases for young people. But within that case, Mumby considered whether or not the case should move into the Court of Protection. And he favoured at that stage the applications for authorisation remaining within the family court. And one of his thinkings, and I'm aware of a judge locally who also shares this view, so it is something that you might come across locally, But one of the main factors appeared to be that the children's guardian would remain acting in that role, so long as the cases remained within the family court. Whereas clearly CAFCAS, the Court Advisory Service to the Family Court, do not have any role within the court protection, and matters would move to the official solicitor. But as this had been a care case with continuity of representation, Mumby was of the view that the guardian was better to remain in that role, and as well as matters such as judicial continuity. So that's a perfectly valid reason for keeping a matter that could go to the Court of Protection, but keeping it in the family court instead. And illustrates really the fact that we can do these things in more than one way. So very well, then moving on a little bit to the impacts of the liberty protection safeguards. And as I've said, I think Neil Allen's speaking about this on a different day. So I won't go through this in any great detail, but it is relevant to transitions. So those of you with an interest in working with this age group have to be aware that systems are changing. The liberty protection safeguards that are coming in to replace the Dole's scheme are now thought to be going to be implemented in April next year. And there will be, in effect, an administrative scheme to authorise the deprivation of those aged 16 years old and older. That arises from the Law Commission recommendations and was a recommendation that was adopted. So at that point, the applications that we're currently seeing in the family court to authorise deprivation of liberty will be encompassed within the new scheme. And 16-year-olds will fall to be dealt with alongside adults' cases in terms of their rights to challenge, the time limits, the process, the procedure, effectively. They will be scooped up within that scheme. But I thought it was maybe worth, whilst looking at this age group, to just briefly look at the position that we have around dolls in the meantime. And this is a very brief guide to it, as I say, and as you'll all know, deprivation of liberty by itself could encompass more than an hour, so I'm certainly not going to be able to go through it in any great detail. It's really just by way of a recap. That when thinking about this age group, we obviously now have the Supreme Court decision of Re D from 2019, which made it very clear that where a 16 to 17-year-old either cannot or does not consent to their confinement, and obviously the conditions have to be objectively a deprivation, then the parents also cannot consent. And importantly, where there's a care order in force, the local authority can also not consent. And that's set out on this flowchart effectively. I've referenced at the top of it the Law Society guidance. If you're considering objectively whether or not something is a deprivation of liberty, the Law Society guidance around young people and deprivation remains extremely useful with their working examples. And if you work your way through where parents, and sometimes in disability cases, parents make use of Section 20 of the Children Act, which is effectively voluntary accommodation. If it's an arrangement under Section 20 by which the parents and potentially the young person, depending upon capacity issues, have agreed to them either having short breaks or a form of respite or even longer care if that's what's needed. If it's voluntary, then parents can consent, provided it remains an appropriate exercise of their parental responsibility. And that's an area which I think is sometimes a court of arguments with the local authority. But the parents cannot consent once that young person reaches the age of 16. And that's what we take from Re D. And then, of course, if there's care orders in place, as I've already said, just looking down the other side of the flow chart, then parents and local authority cannot consent. So I think we have that fairly clearly now from the Re D case. Right, just a very brief word on unregulated placements. Some of you will have seen this in the press very recently. Unregulated placements are a thing to be aware of if you're working with young adults, because they very often find themselves, particularly where there are either capacity issues or behavioural issues, and those two things may or may not be connected, but they very often find themselves within an unregulated setting. and that effectively means that they're not within Ofsted. There's currently a government consultation open for a period of 8 weeks from February, ongoing at the moment, which is why it's in the press, with a view to preventing councils using unregulated placements for under 16-year-olds. Nothing in terms of 16 or 17-year-olds, which arguably still leaves that category of young people at risk, which is a huge shame. And also nothing about actually what's going to replace these this reliance on unregulated placements, which are only really drawn upon by local authorities as a last resort. There's a whole line of authorities, which some of you will no doubt be aware of, highlighting the problems with unregulated provision for teenagers. And this is the provision that often provides accommodation, but the care package is then potentially or should be built around that young person. And these are just some of the cases in which the judiciary have had cause to effectively say there is nothing else that I can do than leave this young person in substandard accommodation. And it's really reached crisis point. The Children's Commissioner has been very vocal on it and has produced a number of reports urging a ban, as they put it, on the use of unregulated placements. As I say, the general thinking is that it doesn't go far enough actually under the consultation, because it's still leaving older teenagers at risk. So I've given you the references there. Again, due to time, I'm not going to go through each and every one. And there is practice guidance in force if you do find yourself in a position where, and it's perfectly possible that it will come up in the Court of Protection, where the 16 or 17-year-old, when you come into the case, they are in what's classed as an unregistered care home or unregulated placement. So the approach is set out there. All right, we'll just spend the last 5 or 10 minutes then, because I know there's meant to be time left at the end for questions. So we'll just spend a little bit of time looking at the inherent jurisdiction. The inherent jurisdiction for relates to both children and adults. It operates there in the background effectively as a safety net behind the statutory provisions. And it's useful where there are concerns around vulnerability, but they don't fall within the Mental Capacity Act 2005. And when you bear in mind that the family court's jurisdiction to make protective orders in the form of care orders effectively can't be operated past the age of 17, you may well have situations where a case could well be either partly in the Court of Protection and partly need the support of the inherent jurisdiction, or, as I've already said, as a result of capacity concerns, it falls within the inherent jurisdiction until assessments are properly arranged. And usually the inherent jurisdiction is used to its best effect when it's a facilitative jurisdiction. So it is not there to impose restrictions, and there's clear authority on it, which I'll give you in a minute. It's not there to impose restrictions upon the young person themselves. It is there to facilitate effectively a safe space for them to be able to make their own decision making, or for their capacity to make those decisions to be freely assessed, which is where it sometimes fits very neatly into Court of Protection work. Because it operates if there's a concern around the use of influence or coercion. Under the age of 18, for those of you that aren't childcare practitioners, it can take the form of wardship, which effectively allows a local authority to make arrangements for accommodation. But it operates perhaps just as usefully for our purposes over the age of 18, because injunctions made to protect a young person can proceed to and continue past the age of 18. And that comes from the 2015 case of SO, when Baker J, as he was then, ruled that the court had the power to extend injunctive orders beyond a child's 18th birthday, and that arose because of the protective nature of the jurisdiction. So that, in effect, if you have an order, for example, regulating the contact that a 17-year-old girl should have with her violent boyfriend, and she suffers with a learning disability, but there's no clear capacity assessment, And when a capacity assessment is carried out, it said, well, actually, she does have mental capacity to make decisions around contact. And she is expressing a wish to be with the boyfriend. It is possible then to say to the inherent jurisdiction, well, actually, there are concerns here around his influence and coercion. I'm sure that's a theme that's familiar to a lot of you. But that means that any injunction that's made protecting her at under 18, the court can then be asked to extend its powers post the age of 18. Whether or not it will do so is a different matter and depends on all the factors in the case. But it remains there as a possibility. Yes, and I've said there that this is a really useful, sometimes transitional tool, often used in the short term to provide an element of protection. However, it has its limits. It's sometimes said that the inherent jurisdiction doesn't, and it's judge made in effect and without restriction, but it does have its limits. Mr. Justice Cobb held in the 2019 case of Redcar, that was a case in which an injunction had been made against a young person to prevent her from going back home to live with her mum and dad upon discharge from a mental health section. She, in effect, was expressing fear of her parents, didn't want to go home. But the injunction was made in the first instance, and it was framed in the sense that it was against her and restricting her movements. And as I say, Cobb J made it clear in that case that that's not the purpose of the inherent jurisdiction. It is there to facilitate decision making, as I've said. And the emphasis in these orders has to be on enabling that young person, not restricting them. So it's just important to bear its limits in mind. Another area in which the inherent jurisdiction attracts controversy, and this applies across the board really in age groups, although my interest is specifically in younger adults, is that around the deprivation of liberty of adults with capacity. And there's been a number of cases recently, but perhaps the Mazhar case is the most useful one to look at, which is the Court of Appeal decision. And in Mazhar, unfortunately, the Court of Appeal stepped back slightly from determining whether or not the inherent jurisdiction could finally be used in that way. It said that there's authority at first instance that supports the fact that you could deprive a capacitated person of their liberty, but there is some authority to the contrary. And then there's uncertainty about whether or not it's permissible. And it didn't quite deal with the argument. It was said that it didn't need to on that particular occasion, but it does set out the train of thought and the line of authorities, which is somewhat useful. And all of this really brings us on to, as I mentioned at the beginning, the clash that I sometimes think there is perhaps in culture around children's social care and adult social care. And it's sometimes known as the protection imperative. I would suggest it's particularly strong in transitions cases, although it's perhaps present in lots of different areas. But this tension between paternalism and autonomy. And I've given you there the quote from the 2012 case. There's more recent case law as well looking at this. But this sets it out quite neatly that there's a natural temptation for applicants of any format to seek, and that might be local authority social care departments, quite rightly looking to protect younger vulnerable people, and also for the courts to grant relief to protect people. But obviously, as young adults move towards adulthood, they are then presumed to have capacity to make decisions under the Act, and their autonomy should be supported. So there is sometimes, I find, a tension between the two, both in practitioners as well as the court. And it's important to remember that there is a different approach, clearly, and there needs to be a different approach as people take adulthood. I've given you some guidance which did come from the Mazhar case, because that involved an urgent application to a court out of hours. It wasn't made on notice to the person involved. And the Court of Appeal set out some guidance there for making those type of urgent applications and the information that should be given effectively. So that's always useful to look at. Yeah, I won't simply read that through. I'll leave that there for you. I know you'll have access to this by recording afterwards. So just in terms of concluding thoughts, you'll have seen hopefully within that very whistle-stop tour just the sheer number of different legislative provisions and areas that you need to be aware of if you're faced with a 17-year-old case, and their background, the factors that you need to know about, the different duties that you have to take into account that a public body might hold towards your client if that's the role that you're in. There are a number of different routes that are open to protect vulnerable young adults, and that are important, I would say, for practitioners to be aware of. And effectively, as in most areas of our work, we have to be able to view that person holistically, and know about the various different strands that they may be dealing with, rather than looking at education, for example, separately, or their care background somewhat separately. It is all adding up to being one journey, in effect, that the families have had to take, and it gives rise to a package of care and support that they need from whatever resource. So I'll just end with a couple of quotes that I thought were quite nice. The first is that we spend our whole childhood wanting to grow up faster, but we spend our whole adult life wanting to go back to the simplicity of being a kid again. And I'm sure we can all sympathise with that. I'll just leave you with that concluding thought. So yes, I hope that was helpful. That concludes. Thank you, Alison. I think we've got time for questions.
Thank you so much, Jackie. That was extremely interesting. It's a very interesting area of law, and we both come from a care background, so it's something that we're both, I think, very interested in practice. A lot of questions are asking if people can have your slides, which they can, and they can access the webinar afterwards. That's also fine. So I have a few questions. You seem to have covered most bases, Jackie. So is the Reed-D case the latest guidance on transitional cases and doles for young people?
It's not necessarily the most recent case, but it's the case from the Supreme Court. So it is from the highest court in that sense. So it provides us with the clearest legal definitions. There have been a number of cases since that have looked at individual problems. For example, there's a case of Rees C, and I can send you the citation for you if needs be, that looks specifically at placement in Scotland and deprivation of liberty, which gathered a life of its own approximately, I don't know, perhaps 18 months ago now, when local authorities were finding that they were having to place young people in Scotland with a different regime. And there was a series of judgments around that type of area. So there have been cases since Reed-D, but they're High Court decisions as opposed to the Supreme Court.
Thank you. And how often do you find in practice the transitional cases stay in the family court for elder children?
If they are deprivation of liberty issues, then I'm finding more often than not the family court are keeping hold of them. And I think part of that, even when they have the Court of Protection open to them because of mental capacity issues, I think part of the reasoning for that comes from what Mumby said about the importance of continuity for representation, and that family court judges who may also be Court of Protection judges and therefore have a good understanding of both systems feel that where there's been a children's guardian involved in care cases and they have that same guardian again, it's actually more important that the young person has a continuity of a representative, and therefore they'll retain it within the family court for as long as they can, obviously being aware that there are Court of Protection declarations that could be made if they moved it sideways.
Thank you. Other than Section 25 of the Children Act, can the Family Court authorise a deprivation of liberty?
So within the family court, for there to be an application for authorisation of a deprivation of liberty, it has to go to the inherent jurisdiction of the High Court. Now, that's often dealt with by a family court judge in practice, but technically you are within the inherent jurisdiction of the High Court. So as already been referenced, the Section 25 reference is to secure accommodation, which is a scheme in its own right and has its own safeguards. and I referred to in the flowchart because it has a framework in place. If you're looking to authorise a deprivation of liberty for any age group, I think the youngest reported case is a 10-year-old that was found to be deprived of their liberty. So any other young person up to the age of 17, you apply to the inherent jurisdiction. It's dealt with then within the family division by a family court judge. So it's very overlapping. You are quite often also dealing with other care applications, which is why it stays within a family situation. Where we'll get to with the liberty protection safeguards, when they're implemented, you could then very easily have a child who is in local authority care, age 16, that the local authority as the responsible body under the safeguards has decided administratively is deprived of their liberty and has authorised that. And then the challenge to that will actually lie to the Court of Protection. So again, we're going to have these overlapping jurisdictions, I think, for considerable time to come. I think it remains a bit of a maze.
Jackie, just for the non-children practitioners, can you just, I know you've touched on what it is, a secure accommodation order. Can you just describe the ambit of that just briefly, please? Yeah.
So a secure accommodation order is made really in the most extreme of cases. It's got a specific statutory framework, as I've said. The person asking the last question mentioned section 25 of the Children Act. You can only apply for a secure accommodation order effectively if you can show that no other form of accommodation is going to keep that young person safe from either harming themselves or harming others. And there are strict time limits imposed. The first order is made for something like 72 hours, and then it has to be reviewed by the court. They have to be brought back before the court regularly. And there's usually then steps taken towards a step down. But they are for placement within either forensic or welfare residential units that are very clearly deprivations of liberty. The reason I mention them is that we don't need to apply to authorise them, because very much like mental health law, it has its own working regime and its own built-in safeguards.
Thank you, Jackie. And of course, the child doesn't have to lack capacity for secure accommodation order. Thank you. Could you please provide details about the consultation for unregulated placements?
Yes, I can. If you have a look on the government website, it's currently a live consultation. I think it went live last week. For a period of 8 weeks. I can certainly send Alison the government link for the consultation. It's open at the moment. It was out in the press, I think, last week.
Thank you. That's helpful, Jackie. And I have a comment that says this will be great to share amongst the team because we do work across transitions. It's been very interesting. So that's good feedback. I don't have any more questions. I'm just looking down. I think you must have covered everything, Jackie, to everybody's satisfaction and all the questions that they're going to ask. Oh, there's another question, sorry. Hi, could you please provide details around holistic assessments?
Yes, so that I take to be a reference to the fact that one assessment can stand. So just to take a step back from it, where a young person has a entitlement to a transitions assessment under the Care Act, but because of their age, they may be 14 or 15. And I have to say, in my practice, it's rare that we see transitions assessments starting, unfortunately, until they are much later than that. They should be started at around 14 to 15, but quite often, unless they're asked for, they don't begin until that young person is maybe 17. So I know that will vary in various practice areas. I'm probably annoying a lot of people in tarring them all with the same brush. But where there is a right to a Care Act assessment, but perhaps there is already an education and healthcare plan, this is one example. The education and healthcare plan should stand as one piece of assessment, and that's set out within the SEN code. So, and from the SEND code, we take the lesson, and the phrase used sometimes is that the family should only have to tell their story once. Because alongside education and Care Act, you may also have an assessment of needs under the Children Act, because Section 17 of the Children Act means that you're entitled to various levels of financial support and input. And I think we can all imagine these people should not have to repeat assessments again and again with various different professionals. So the idea of a holistic assessment is embedded within the Care Act guidance, that transitions assessments can take the form of Children Act assessments as child in need type assessments, but those documents should really specify the areas that they are covering, and they should build in the various domains so that it involves less, we hope, assessment fatigue for the young person and their family. My advice is always that if you are doing a single piece of work under a number of different areas, that pro forma really needs to, and they don't always, but it needs to set out that you are encompassing a number of different areas and make it very clear that you are not ignoring an area of entitlement effectively. But if it's an EHC case, then they are specifically that the plan itself is built to be a holistic assessment.
Thank you, Jackie, and thank you so much for your time. I'm sure everybody's found that extremely informative. Just in terms of obtaining your slides and everything, we will provide all of those on the website, and you can watch this later if you've not been able to see it today. I've just got, see if there's any. No, it's just very positive feedback, Jackie. So that's nice for you
to know. Thank you very much for asking me, Alison.
Thank you very much for your time, Jackie. It's been great. Thank you. Good afternoon, everybody. Thank you for joining us.